You're listening to the Quint's podcast.
Just a day after Delhi police arrested Bengaluru-based climate activist Disha Ravi on charges of sedition for having allegedly edited a toolkit which Swedish environmental activist Greta Thunberg shared on Twitter, two more activists came under the spotlight, Nikita Jacob and Shantanu Muluk. Who are they and what is the police alleging? Nikita Jacob is a practicing lawyer in the Bombay High Court and Shantanu Muluk is an environmentalist who had quit his aerospace engineering job around 6 months back to focus on the parched regions of Vidarbha and Marathwada. From the press conference held on 15 February, we know that Delhi police had named the three accused, Disha Ravi, Nikita Jacob and Shantanu, as the editors and creators of the toolkit who laid out an action plan for 26 January. Their aim? To create misinformation and disaffection against a lawfully enacted government. The police further revealed that a Zoom meeting took place on 11 January, attended by Jacob and Shantanu and organized by the Poetic Justice Foundation, which the police deems as a pro-Khalistani organization, in which the modalities of the Global Day of Action were worked out. In her defense, Nikita Jacob has stated that the toolkit was simply an information pack and that her intent was never to incite violence and there was nothing illegal in what she did. Shantanu Muluk, who was granted transit anticipatory bail on 16 February after Delhi court issued a non-bailable warrant against him and said the following in his bail plea before the Bombay High Court. Vendetta has trickled down from politics to the house of a common man, making a mockery of the rights and principles enshrined in the Constitution of India. That such vendetta, which is the dark face of authoritarianism, is the real toolkit for devastation of not only of democracy, but also the basic human rights. Now, naturally, the statements of the police and the accused contrast. So, in this episode, we are going to try and see where the law stands on toolkits and sedition and how the law should treat Shantanu and Nikita Jacob's case. For this episode, you'll hear from Vakasha Sasdev, the Quint's legal editor. You're tuned in to The Big Story, the podcast where we dissect the headline-making news for you, and I'm your host, Himmat. So what have Nikita Jacob and Shantanu been doing about all of this, especially after the arrest of Disha Ravi? Nikita Jacob has accepted that she did play a role in gathering support for the farmers' protest on social media with activists globally, but has maintained that there was nothing illegal about it. In her statement to Delhi police, which was accessed by Hindustan Times, she stated, and I quote, "The information contained in the toolkit does not in any manner incite riots or violence and is simply an information pack with information from various sources. No weapons, no violence, no mention of anything remotely violent in the toolkit or any of our communication." Jacob, who is also a volunteer of a global environmental group called Extinction Rebellion India, also known as XR India, further stated in her statement that the toolkit was prepared by XR India volunteers to provide a simple breakdown of the process for an international audience. Her statement further read that one of the XR volunteer partners, Fridays for Future, shared the toolkit with Greta Thunberg, seeking her solidarity with the protesting farmers in India. And this is where Disha Ravi comes into the picture and her subsequent arrest. Now, the other accused in the case, Shantanu Muluk, is one of the founders of XR India Group and was in touch with Jacob about the toolkit. In their press statement on 15 February, the police said that Shantanu was the owner of the email account from which the toolkit was created. Here is what the police said exactly.
The initial examination of Nikita revealed that she and her associate Shantanu and Disha had created the toolkit Google document. The email account created by Shantanu is the owner of this document and all others are its editor.
The Delhi police further revealed that a Zoom meeting took place on 11 January, attended by Jacob and Shantanu, and was organized by the Poetic Justice Foundation, which the police has deemed as a pro-Khalistani organization, in which the modalities of the Global Day of Action, which is what the toolkit was called, were worked out. Delhi police has also written to video conferencing app Zoom, seeking details of participants who attended the meeting on 11 January. The police further said that a Canada-based woman named Puneet connected the three activists to the Poetic Justice Foundation. On 16 February, different benches of the Bombay High Court heard the transit anticipatory bail pleas by Nikita Jacob and Shantanu Muluk. Here's Vakasha Sasdev, the Quint's legal editor, explaining what happened in the proceedings.
Now, Nikita Jacob's hearing took place in the Bombay High Court today. It took place on Tuesday. Now, at this hearing, before there were a lot of sort of genuine like detailed arguments on why she should be given transit remand or not. The first thing which came up was a procedural objection by the Delhi police, who argued that there is no sort of provision for transit bail within the Code of Criminal Procedure. Now, the Code of Criminal Procedure is where you get your power of bail, anticipatory bail, all these things from. Now, what they're saying is that technically there's no such power. So if you really want to get bail or anticipatory bail, you have to go to the court which actually has jurisdiction over the case, which is one of the courts in Delhi. Now, if that were the case, then I mean, so now that's obviously a key point which the judges have to consider. At the same time, what came up in the middle of the case itself was that the Aurangabad bench of the Bombay High Court had already granted transit remand to Shantanu, the other sort of key accused at this point, right? So we know there are three. There's Shantanu, there's Nikita, and there's Disha Ravi. Now Shantanu had already got this transit bail and transit anticipatory bail from the Aurangabad bench. So even though the Delhi police were raising this procedural objection, the Bombay High Court was then, okay, wait 1 second, we've already gone and granted it to the other accused. So they're sort of now going to just have a brief consideration of the power to grant that kind of thing, and then take a call on whether to grant it to Nikita Jacob tomorrow. Now, there have been, it's sort of a mixed bag of things. I mean, there have been some courts which have granted this kind of thing, some courts which have not. One key thing is that, the high courts have a power to do sort of complete justice when it comes to pass any orders in the interests of justice when it comes to the Code of Criminal Procedure, Section 482 of the Code of Criminal Procedure. So even if the CRPC doesn't specifically give a power of transit anticipatory bail, the courts could try to locate that power within that. Now that's something which is going to come up because there'll have to be an examination of precedents on either side. Given that the court's power under 482 has been used before to grant this kind of bail, given that one accused has already just been granted that, one would expect the Bombay High Court to probably grant bail to Nikita Jacob, but they are going to have to consider the arguments made by the Delhi police today. So we'll know more about that on Wednesday, on 17th February, when the order of the court comes. So, this obviously becomes an important point, not just for Nikita Jacob's case, but for other cases going forward as well, because we've been seeing this issue of people being picked up from one state, taken to another, and the kind of chaos that causes has been something which has been coming up more and more in a lot of these cases, whether it was the Bhima Koregaon case and now here. So, these are issues which are actually quite important, not just for these specific cases, but in bigger term sort of precedent and justice delivery. So we're going to have to see what is done in the court tomorrow, and obviously, the Quint will keep you updated on all of that information.
Jacob's legal team reiterated in the hearing that the toolkit does not talk about violence or taking over the Red Fort, and it only mentioned supporting farmers. Her legal counsel, Advocate Mihir Desai, stated that based on the content of the toolkit, the charges of sedition cannot be invoked. The Delhi police claimed that the toolkit was used to spread misinformation and disaffection against the Indian state, hence justifying a charge of sedition. But is that all that's needed to justify a case of sedition? Here's Vakasha Sachdev again, taking you through the Supreme Court's jurisprudence on sedition under the IPC.
So the first issue to look at here is obviously now, do these claims about the toolkit itself really amount to sedition? And I think if this is all the police have, then it's going to be very, very difficult for them to really kind of take this case forward, because what you have to understand with sedition is that it is a very serious offense, and the Supreme Court acknowledged that, because remember, this is something which comes from a colonial legacy. Now, it's not something you want to continue unless it's used for the absolutely most serious cases. So in 1962, the Supreme Court in the Kedarnath case, it clearly said that you have to have a link to actual violence, based on what is said, which is supposed to be seditious, there must then actually be some violence which takes place. So it has to be so clearly inciting imminent violence, or so closely tied to some propensity for violence, what you're claiming to be seditious, that there is no other choice but to see that there's a public order risk to it, right? Because essentially when you're going to say that, okay, we're going to restrict someone's right to freedom of speech or restrict their right to freedom of expression, there are very limited grounds in which you're going to be able to do that. One of those is a severe link to public, threat to public order, but there has to be some actual imminent violence, an incitement to that, which comes about as a result of the allegedly seditious action. Now, if we look at this toolkit, from the versions of it which can be accessed, whether it's versions of the old ones which are still up on archive.is, or whether you're looking at the versions of the later version which is still easily publicly available, none of these documents, neither of these two versions actually has anything relating to violence or any calls for violence. And no matter whether you disagree with whether someone with a Khalistani link may be involved with the creation of that document, even if it is, and as long as the document itself says nothing about inciting violence, and in fact, to the contrary, if you look at the documents, they actually talk about using lawful measures only. Now, once you've got that, it is very, very difficult to now say that this is going to satisfy the test for sedition under the Kedarnath case. And this is not, and Kedarnath case was a constitution bench judgment in 1962. It's been followed and built upon by the Supreme Court for decades since. In fact, in the 1990s, there were a bunch of cases, dealing with sedition law coming from Punjab itself, and they specifically involved people raising pro-Khalistani slogans. And despite the fact that you had cases where someone was clearly saying Khalistan Zindabad and things like that, the Supreme Court expressly held no, that's not sedition unless and until you actually have some violence coming out of this, or that there actually has to be some instigation of imminent violence. Now, if you look at what this toolkit is doing, it's got no instigation of violence at all, let alone imminent violence, let alone actual violence. To then say that it's going to be, linked back to the 26th January violence is a very, very big stretch. Now, for the police to be able to prove it, they have to show that maybe there was some subtext, maybe there was a secret hidden message with some code, something like that you'd have to show essentially to be able to say that creating that toolkit and the content of that toolkit was in any way seditious. And that's very, very difficult to see at this point. Now, are they going to maybe pick out something else, show some other emails, show some other conversations which took place about conspiracy to commit violence? Sure, maybe that could work. Maybe that would be enough, but there's no sign of that. And the police are pegging so much of their case on this toolkit at this present, right? At this point of time, or the Zoom meeting when it was decided to create the toolkit. So if the toolkit becomes the focus of the case, then that's pretty much going to be a non-starter for sedition because there is no incitement to violence within it.
However, the protest toolkit, as accessed by the Quint, nowhere asks or incites the protesters to resort to any violent means or create any public disorder. So, where do those sedition charges stand? Doesn't the law on sedition require some sort of incitement? If you liked listening to this episode, please subscribe to The Big Story for episodic updates. We're available on Apple, Google Podcasts, Spotify, JioSaavn, and most of the other popular podcast streaming platforms. For other podcasts, please log on to the Quint website, and for any feedback, please shoot an email to podcast@thequint.com.
Thanks for listening. Log on to the Quint's website and check out our other podcasts.